All right. Hello, everyone. Thank you for joining us today at What I Learned at My First Trial by Furhad Sultani. My name is Cassie Seaton, and I am the Outreach Director here at the Stritmatter firm. Our firm was started 75 years ago in Hoquiam, Washington, and we still have an office there as well as our main office here in Seattle. Three of our partners of our firm are former presidents of the WSAJ, and our namesake, Paul Stritmatter, was also the president of the WSBA. A significant portion of our practice involves partnering with other lawyers on major personal injury and wrongful death cases. The WSBA has licensed the Stritmatter firm as a sponsor for mandatory continuing legal education and approved our webinars for credit. You'll receive one free credit today for attending. Please stick around at the end of the webinar, at which time attendance will be verified by writing your bar number in the chat. And then I also encourage you to submit questions via the question and answer box throughout the presentation, and I will put the written materials in the chat for your review. Our presenter today is Furhad Sultani. He is a new attorney at the Seattle Stritmatter office. He was admitted to the bar in the fall of 2021 after graduated from UW Law the previous year. He currently has a diverse caseload focused on personal injury and civil rights. At this time, I'd like to hand it over to him.
All right, thank you, Cassie. Well, good evening, everyone. Good afternoon, I guess. So I'm gonna tell you kind of a little about what I learned from my first trial experience. So I, as Cassie said, was barred in November of 2021 and got an opportunity to sit second chair with Karen Kohler on a case that had been filed almost 8 years ago. And maybe I'm gonna show the sizzle reel because I think it really puts everything into perspective about this case. See.
We believe she murdered. And we believe she murdered him in cold blood. Shocking accusations. A forbidden love?
Forbidden love, absolutely.
Salacious rumors.
I would like to think that's not true.
All leading to one unbelievable bombshell. Your husband was your uncle. Yeah, a lot going on there. We believe she murdered.
All right, so let me tell you what this case was about before we start to talk about what exactly it taught me. So this was a civil murder case. The crime had happened in a foreign country, in Belize, and the property in dispute was the family apple orchard. And when I say family, so we represented the decedent, Tim's, his two children, two adult children, and they were suing because Tim had actually transferred all his, put in his wife / niece's name, all the life insurance proceeds and the family farm, the will and deed to the family farm in her name before he had died. And I think some of you might know, based on the Slayer statute, you can't profit from a crime, especially a murder. And so we had basically initiated a lawsuit to get all this property and the life insurance proceeds back in the hands of Tim's adult children and away from Tracy. And then in the middle of this, in the clip, you saw Karen Kohler, who's a partner at our law firm. And I don't know if you know, but that was John Henry Brown, who was the defense attorney there. And he's made a name for himself as the defense attorney for Ted Bundy. So we had a really, really fascinating case occurring in Grant County, so a really tiny county in Washington. But it all really boiled down to this family that, you know, had grown up at this farm. They had made it into a property that was really valuable to them sentimentally. And they were trying to carry out their father's legacy. So now that you know about the case, and my involvement actually occurred pretty late in the 8 years, as I had not been barred yet, but I had the opportunity to put on a couple focus groups before this went to trial. And I can't stress enough how much focus groups offer you insight into the thinking of your jury, but it also really teaches you about the case. And as you're hearing their comments, you realize ways you could explain things better, or themes you could use. So those focus groups, because I was put on the case so late, really helped me make sure that I could fill in those holes in the case, and I got a good understanding of the case file from it. And anyone that has any questions or anything, feel free to pop them in the chat at any time. So the best time to prepare is always before a trial. And I touched on this a little bit. Conduct focus groups. It does a tremendous amount of legwork in helping you understand the case, but also we learned very early on from a focus group that we wanted women on this jury. Tracy was as an individual, very sympathetic defendant. During the focus groups, a lot of male jurors didn't think that she could kill her husband. And so we knew that would be an element of how we were to decide who ultimately we wanted on our jury. And then make a list, check it twice, and figure out that you have everything that you might need there at trial. So this was slated for a week and a half of trial. It ended up taking 3 weeks. Pack extra clothes. We were expecting for half day. We were expecting to head back half the week. Luckily, we had brought extra items and we could last the whole week, full week there without having to drive back to Seattle and drive back to Grant County. As far as tech, I had a Mac laptop. I made sure I had all the extension cords that could, operate with any TV, because we knew we were going to be showing exhibits on them. We had backups of the case file on a hard drive just to make sure if, and that actually did come in handy, because it was tricky to be able to show things off our remote laptop, or a laptop doing remote, than it was just to pull it off the direct PDF case file. And you didn't have to deal with slower Wi-Fi speeds. So, all this kind of went in the preparation and thinking before trial, like, what are we going to need? How do we want to make our case, and how do we want to show it? And don't over prepare is also important. So Karen does trial a little bit differently than a lot of other partners at our law firm. She doesn't prepare witnesses until very late or during trial. And that's partly because you can't anticipate what's actually going to come next until you're in trial and you're seeing, after MILs, what's allowed in. Oh, we opened the door to this. What exactly, how can we shift our thinking? How do we want to bring in this witness? And so really having a flexible schedule, as much as you can, is going to be really important. All right, and so I got to argue all the motions in limine. And I mean, I heard this was atypical for any trial, but the judge reserved on a lot and actually flipped back and forth sometimes. And so, an MIL we had argued maybe 20 minutes ago would be re-brought up later in something else we were talking about. And so I really learned early on, keep pushing to get in what you need, and, you know, keep out what you don't want in, and keep making that argument, even if you don't think you'll win. So we had photos that we had kind of just thrown in to annoy the other side. And I didn't expect these were gonna, stay in the case. The other side was clearly really grumpy about them. We really didn't need these photos. It was just to kind of poke at them. And judge asked me, why do you need these in the potential exhibits? And, I had just said, well, they're potential in case we need to impeach the witness with them. And not necessarily the best argument, but it ended up winning the day. And so, I think when you're in the thick of it, you might think that your argument doesn't hold that much water, but we ended up keeping these in potential exhibits and kind of annoying the other side until the very end. Because they were really concerned about these being displayed. And that kind of leads to my next point is, don't give the other side any ideas, because in their MILs, they had included something to like keep out these photographs. And, they weren't in our potential exhibits. They weren't, we had actually saved them in the wrong file. So they weren't with all our other photos. And so we added them at the last minute into our potential exhibits to kind of make a point to the other side, and we won the argument. So, make sure you're not overthinking things and giving the other side something to harp on and something to poke at you with. Well, my favorite part of any trial is voir dire. I've had the opportunity to watch a lot of great attorneys conduct voir dire, and this was no different. It's obviously super important who you have sitting on your jury. And you really need to, as much as I think online sleuthing helps to find a good juror early on, it's also where you can, jury selection and the stories the jurors share is where you build that, you start your story off. And so from the focus groups, we had learned really early on that our biggest issue in the case is that it's a civil murder case. And so, we heard a lot of the focus group attendees talk about, well, it's not beyond a reasonable doubt. And so that was the first go-to. Do you know what a beyond a reasonable doubt is? Well, do you know what preponderance of the evidence is? Why is that different? And it wasn't the lawyer telling them, it was they were educating each other. We saw that dynamic play out. And kind of a missed opportunity for the other side along with this was tackle your bad facts. And so combine that with looking at people online. We actually had a priest that was on the jury. I had looked up this guy and I said, well, he seems pretty conservative. He might not appreciate the relationship that the defendant had with the decedent. And, he was pretty quiet. It didn't really come out, but, nobody asked. There was a poke by Karen. Karen was conducting voir dire, and there was a poke at, well, have you ever heard of Fruit of the Passionate Tree, which was a Discovery Channel show that Tracy and or the defendant and her attorney were on. And nobody said anything about this relationship that was uncle and niece. And I think it did have an effect on how some jurors were biased. But yeah, I think it really all plays in, like, how you want to create that cohesive unit was really important in building your story. We had jurors already thinking about suicide, like, because the defendant's main case was the suicide. And we had one juror talk about how his friend committed suicide, and it was so elaborate, it was so well thought out. And you compare it to the case we had in front of us, and it was, you know, initially the story was that it was an accident, and then it was that that he actually committed suicide, or that, there was someone in the trees shooting at him. And so the juror that was talking about his friend's suicide, which was very emotional, and how well thought out it was, how you could, it wasn't like this individual was calling and joking around with his friends, the night before, or talking with his kids the night before, like everything was normal, or making plans for the future. And so we really undercut their defense with voir dire. The opening was very, very dramatic. A couple tips that I learned in the opening really early on is that never overpromise. If you can't deliver, the jury is going to remember that. And, lay out your full case, but keep some things that you don't know if they're going to come in. Make sure that you don't announce that, because now you're breaking a promise. There was a lot of things that the defendant side hoped would come in that ultimately didn't, and he had somewhat brought it up during opening, or alluded to it during opening, and it fell really flat when those things couldn't be talked about. We had this prop gun that was over here, so 3D prop gun that was printed especially for this case, and we utilized it not only in opening, but throughout the trial. We had our experts hold it and try and show us exactly the path the bullet took. The defense expert held it in a weird way, and one of the jurors asked, "Why did you hold it right here when he actually was shot over here?" And the defense expert said, "Because my arm doesn't bend that way." And we kind of know, well, gosh, you can't, like, if your arm can't bend that way, how do you expect the decedent's arm to have bent that way? And so it really, really allowed us to show, not only tell the jury what happened, but to show them what happened. And I think I also stood up at one point, and because Karen was around Tracy's height and I was around Tim's height, and we compared, how is it for me to shoot myself or get shot in the head? And I think it really drove home the point that we were trying to make. And it also kept the jury engaged. They weren't just hearing a droning on of the recitation of facts. We had a timeline go up. PowerPoint presentation, I think, have been great. We weren't allowed to use PowerPoint, and so, at least for opening, but we had, put up a piece of paper, and then the timeline was just written out. It wasn't everything. We didn't know what else we'd bring in at trial, and then, it was our job to make sure that after, and I'll talk about this at closing, we added to it. We added to the timeline that was brought in at closing. We're saying, oh no, we didn't only have, the 1 year basically from his use starting to go out to his death. and him transferring all his land and property into, like, we have all these other things that happened. And the jury was able to see, okay, they checked off all these things we talked about. In July they were soulmates. In August they went to Montana. Then they, the first will was changed over into Tracy's name. The quitclaim deeds were signed over, and this is only 4 months later. And so the jury was able to see, not only did this all come in, and it was explained to me not only in opening but also throughout the trial. The opening tied everything together with a neat bow at the end. And finally, make it memorable. So keep it simple and make it memorable. Keep it simple. We really didn't go into detail about all that they would hear, because that was the job of the witnesses. But there's a portion where Karen actually got onto the ground and was hugging as if she was Tracy, and spooning with her dead spouse, because that is what had happened for apparently 2 hours. And it was kind of the most incredulous part of the story. And so, it was really, I think it was at the end when we were talking with jurors, they remembered that. And they remembered how ridiculous it was to see the lawyer like that, but also how ridiculous that story sounded and looked. All right, so I'll move forward to the witnesses. As I talked about earlier, prep but don't overdo it. A lot of what we were asking the witnesses did change. We wanted them to sound unscripted. And we weren't really sure what was going to come in with some of them, because the judge had reserved on a lot of things. And as the case changed, we knew that we needed to, have an additional witness talk about this. And so it wasn't a quick outline that was, that foresaw anything that could possibly be asked, and then it was culled down. It was kind of, it was list 3 goals that we need from this witness. How are we going to get there? And with this, we actually had international witnesses. And so now we have all these high-tech TVs and even out in Grant County. And so we actually had their depositions recorded. And so that's how we played them, and we had it edited down with the portions that were relevant. And in a way, it kept the trial quicker, but it also allowed the jury to kind of see a different medium. And so it wasn't like we were just putting on witness after witness. I think the Zoom witnesses and the video taped witnesses broke up that kind of what might see as the time kind of just droning on, because it was this change and a shift. A really, really key lesson that I learned was make sure you keep your expert reports up to date. So we had the defense had an expert show up that had actually a new opinion. Well, that opinion was disclosed the day before trial, and that opinion does not get to come in. So it was really important that you make sure that your expert reports are up, that your expert can talk on all things you plan on him talking about, because it really, their expert witness fell really flat because they weren't able to share their full opinions. And last but not least, don't open the door. So I think there was one really key time where we had actually tried to keep out the records from Tracy's divorce, because it talks about a very messy relationship that happened, or really messy gossip that happened with the decedent. And so we really didn't want this gossip to come in. Well, bringing up the divorce records and the child custody battle, all this gossip was in there. And so we accidentally opened up the door. But luckily when they were doing an offer of proof, it didn't really end up coming out, because they couldn't link this gossip with his supposed depression and this possibility of suicide. I've touched on it a little bit, but technology is your friend. I think we're in an age now, post-COVID, where a lot of the courts have, been willing to embrace kind of the ability to have multimedia. And I think everyone should be utilizing that. Everyone should, be displaying exhibits, not only printed, but up on screens. It was really critical that we had displayed some of the documents on the screen that were highlighted. So we were going through with an expert, we were, okay, what is this? And the jury could very clearly see what the document was that they were looking at. 3D printing made that prop gun pretty great. And I think it really helped tell our story. The jurors were constantly engaged with what we were telling them. And having the ability to use PowerPoint or other tech, you can make changes really quickly. And so things that, if we had to print out everything, there was some documents that we, with a witness that we didn't know would come in, and it came in the last minute. And so we were able to quickly pull it up on the screen. Or for closing, we had that timeline, and we just took a photo of it and then had it on the PowerPoint presentation. So it was very, very important and helpful. And I kind of already talked about closing a bit in the opening, but make sure that you kind of use those same themes and those same items that were talked about in opening in the closing. Have a straightforward narrative. The jury at this point had been hearing 3 weeks of testimony. They didn't need to be talked at, I think that phrase is, well, do you remember when you heard this? And then, but it was really clearly evident that, there was a intact timeline that was already talked about at opening, and this is what it built on. Don't try and take the defense's closing and co-opt it in yours. You can think about stuff that the other side said, and the other side, in this case, the defense really went after the fact that, the decedent had a will, and it clearly named his niece as the heir to everything. And they basically, utilize that as their main theme. This is the will, this is his heir. But that was kind of lost steam when you looked at like all the things that everyone else was saying about this relationship, and how how he didn't foresee, someone killing him for it. And so I think you really want to take whatever the defense's main argument is and just undercut it as quickly as you can, and be passionate. This is kind of like the be memorable portion, but I think the closing really hit home for a lot of people. A lot of the jury afterwards said that the closing is what kind of sunk the case for them. And so I think it's really important that you just remember that your closing needs to build off those blocks that you've already set out, but it can be a straightforward, easy narrative. Final thoughts. Rely on your teammates. So we had a lot of calls back and forth throughout the trial, and WebEx really allowed this to be, viewed by the whole team, and so everyone was a part of it. We talked about, getting certain witnesses over here, and but anything that showed up, whether I was having a brief that needed to be got out, within the hour, at points, I needed something briefed up. Someone on my team was already starting that, and then I could just hop in and make sure it was all settled and then go back to trial within the lunch hour. Sometimes make friends. So I ended up getting fairly familiar with the bailiff, and so there was quirky things about Grant County, and the bailiff, instead of judging me for not doing it right, would just give me that information. And we actually had a law firm that was really close by reach out to us, and so we were able to have that working space for the whole trial, which was great. And last but not least, just be yourself. I think that was the most important lesson that I learned from this trial, was that no matter, you can't play a character and get a jury to believe your story. It's going to come off as not authentic, right? So I'm in Grant County. I have, my name is Furhad Sultani. It's not really, what most people are gonna meet someone with that type of name. I'm from Seattle, and so I could be portrayed as this big city slicker. But I think a lot of how we made the case is just being true to ourselves, and not having to put on a performance, because I think the jury can see through that, and can tell that if they can't believe that you are who you're pretending to be, then they're not going to believe you. They're not going to believe your side of the story, your side of what occurred. And so you really need to be your authentic self. So those are the things that I learned from my first trial. Any questions? Well, I'll invite Cassie back on.
Thank you, Farhad. That was great. And just so anyone knows, I can allow you to be heard if you have a comment and not a question. So also let us know if you'd like to do that. But thanks, Farhad. That was a great presentation. I would ask everyone to please put your bar numbers in the chat, and that way I can record attendance. And then you will be receiving a survey after this. So we would appreciate the feedback. We are aiming to host one CLE a month, so it helps with our future CLEs. But thanks so much.
Thanks, everyone. Paul's question, didn't JHB also lose the Ted Bundy case? And I guess so. Hey, good seeing you too, Isaac.
All right. I think. Okay, thanks, Furhad.